Black line right there. Face the camera. Say your full name.
Jerome Dwight Dean.
Thank you, sir. And this is case 23-056283, State of Michigan versus Jerome Dean, counsel.
Thanks, Judge. Good afternoon. Steve Vincent for the people.
Your Honor, Reagan on behalf of Mr. Daniel Wade upon writ extended at this time.
Court will enter not guilty plea on your client's behalf as to bond.
Your Honor, the people are going to be asking for a $20,000 cash, no surety bond, tether house arrest. The investigator's report was short and sweet. However, Judge, we ended up talking to the complainant in this matter. Allegedly, Judge, this was a direct result of her not wanting to be involved with the defendant going downtown to pick up drugs. And Your Honor, subsequently, she was basically made to be in this vehicle. And I'm sure Your Honor, as well as defense counsel, saw that the defendant ended up assaulting her, punching her to the point where she ended up passing out, Judge. There were visible injuries that the people know of regarding her eye, as well as bruises, broken blood vessels, very highly assaultive. Judge, this defendant was also in a domestic violence issue, which the people believe was with the same complainant. However, that matter was dismissed because she failed to appear. This is an ongoing thing, Judge, highly assaultive. We feel as though he's a danger. Do feel justified in asking for that.
What was the amount you requested?
$20,000.
Thank you, counsel.
Judge, as I always say, it's real fun how we can, file a CCW case within 2 days, but anything alleged to be assaulted takes sometimes 7-8 months. This matter allegedly occurred back July 10th of 2022. Now, my client tells me that, right now the complaint keeps calling him, harassing him. He blocked her. They broke up, Judge, at the end of March 2023. And just so happened when he blocked her, they broke up on April 5th, 2023. This warrant actually just gets signed. So, Judge, I don't think there's a coincidence to that. They've been together for the last year, and when he breaks up with her, this happens. Judge. Finally gets signed. I'm asking for a judge to consider a $20,000 personal bond. GPS county report which you that does absolutely no contact. My client says he doesn't want contact. I don't know about the past history about cases being dismissed and not going. I definitely take brother counsel at his word that definitely would occur. But it could be a lot of reasons, Judge, why a complaint didn't go, because she was on, not that what happened or whatever. We don't know. Nobody knows that. But here, Judge, I'm asking for it to look at the timeline a little bit, because I do think sometimes the timeline can be important in case, Judge. Client was hard education, was employed at Dearborn Sausage, Judge, not no longer employed now. He's 55, lifetime resident. But again, Judge, I think that a lot of what you told me, obviously, you don't have the benefit of. All we have is the report in front of you. But I just wanted to add a little bit so you can get a little bit more perspective on both sides.
So, with regard to the Greenfield address, who resides at that location? The indication was at the time of the alleged events, they were living together. You now indicated that they've broken up. So who's at Greenfield?
My client lives at the Greenfield address right now, Judge. She does not live there. My client has blocked her phone number. That says it doesn't reveal anything to do with it. She keeps calling him now.
And people would just like to know, just like defense counsel made the investigative report a hearsay document. Everything that's been said here is hearsay.
Judge, I apologize. You couldn't, brother counsel.
You don't have to apologize. You don't have to apologize.
I'm speaking of not personal knowledge on anything I'm saying in terms of anything in the investigative report. I'm just going by what Mr. Davis conveyed to me about how it starts.
Well, the court is concerned most significantly with the idea that he would have allegedly driven her car without her permission and assaulted her rather significantly to punch her until she passed out.
Over ecstasy.
Sir, while this case is pending, you are not to use or possess any illegal controlled substances. You have no contact with Ms. Rex. Don't call her, don't text her, don't reach out to her on social media, don't have anyone contact her on your behalf. And court's gonna set bond in this matter at $25,000, 10%. Counsel? Affordable?
That would be understood.
I'll give us a bond redetermination hearing Monday morning, August 14. Further dates, probable cause conference, August 18, preliminary exam, August 24, both in front of Judge King here in 36th District Court. Thank you, sir. You can step aside. Mhm. Good afternoon. What's your name, please? Thank you. And Mr. Bronner, you've got some traffic matters we're going to take care of first, and then we'll get to your other charges. With regard to these traffic matters, you apparently missed some court dates. When you missed those dates, a judge issued an arrest warrant for you. You do have the right to remain silent. Anything you say can and will be used against you. And you also have the right to an attorney. If you cannot afford an attorney, the court will provide one for you. Do you understand those rights, sir? Sorry, I couldn't hear you.
Yes, sir.
Thank you. Give me 1 second, and I'm going to give you a new date where you can come to court and hopefully resolve all of these matters. First ticket is P11211013. Charges of driving unregistered vehicle, driver's license never acquired, and improper plates. Ticket P11211016, no insurance misdemeanor and fraudulent or false insurance information. Ticket P1321595, driving while license not valid. And ticket P1360834, driving while license not valid and improper plates. These are all misdemeanor charges. Maximum penalty you face on each is up to 93 days in jail and or $500 fine. I'm going to set aside the arrest warrants, give you a personal bond on all of these, and enter a not guilty plea on your behalf. Your next court date is September 8th for a pretrial in front of Judge Yancey here in 36th District Court. Now, your other matter is case 23-044223, State of Michigan versus Lamonte DeJuan Bronner. Counsel.
On behalf of Mr. Bronner.
Oh, I apologize, Your Honor. Thank you, Mr. Reagan. Steve Vincent on behalf of the people, B719.
Court will enter a not guilty plea on your client's behalf as to bond.
Thanks, Judge. You know what, I want to premise this by saying that the people have been in contact with the prosecutor's office regarding this matter. It is being reviewed, Judge, in terms of how this was charged. I also did, Your Honor, just prior to this case being presented, show defense counsel medical records that support the 2 non-displaced fractures of the now 8-month-old child's head that allegedly this defendant ended up punching in order to cause those fractures, Judge, the people are going to be asking for $100,000 surety bond, tether, house arrest. Now, Your Honor, this defendant is also on probation currently. In addition to the allegations, and Your Honor, they're short and sweet. We have apparently the sister's boyfriend is this defendant. Now, the sister of the defendant's girlfriend. So they're sisters. She was holding on to a baby, Judge. She tries to stop this defendant from an alleged verbal altercation they were having. Apparently, the defendant took exception to that. He ended up punching the sister and ended up punching the baby, Judge, to the point where, like it was stated in the investigative report, the baby ended up sustaining those fractures that have been confirmed through the medical records. And I showed, with all fairness, I did end up showing defense counsel, it was just a CT report. There's substantial medical on that day of the incident, Judge, and I can go through with defense counsel, but I think it's enough just to support the idea that the baby sustained these fractures and support the idea, at least for the time being, Judge, we need to keep the defendant jailed. He is a danger, clear danger if he can cause this to a child. Again, the people have been in contact with the prosecutor's office, specifically the individual that ended up authorizing this warrant regarding these charges. As Your Honor can see, there are 2 misdemeanor charges, but with the allegations on top of the fact that he's on probation, and Your Honor, he's on probation actually for 3 different offenses, one of which is malicious destruction of police property. And Your Honor, he's going to be on probation for that at least for another 1.5 years, as well as a couple other convictions that people do feel justified, even though it's charged as a misdemeanor.
What was that amount again?
100,000.
Thank you. Counsel.
Judge, and I have no issue. I definitely have no issue with brother counsel, Judge. My issues with the Wayne County Prosecutor's Office, who allegedly puts all of this in a report, allegedly says this actually happened on November 10th, 2022. But doesn't get around to thinking serious enough to sign a warrant until February 21st of 2023. Then when the warrant is signed, then when they investigate what they do, they sign it as a mystery. Now, I'm not the person that was there. I can't say what happened, Judge. I can only read what I see in the report, what brother counsel showed me in terms of medical records. Unfortunately, Judge, or fortunately, Judge, we have to go by what's in the court order. Now, unless the brother counsel is going to dismiss this right now and they're going to reissue something, we have to go by what we have. What we have is a misdemeanor, Judge, and I'm arguing bond for a 1-year misdemeanor and a 93-day misdemeanor. Now,
to be clear, though, counsel, you're arguing bond for
what?
To be clear, you're also arguing bond for a 6-month-old child with 2 fractures in his skull.
To be very clear to you, Judge, I'm arguing for a complaint that's a misdemeanor, 2 misdemeanors. I'm not arguing for a hearsay document that's not admissible, but we have no concrete evidence on how that actually happened. We don't know. Now, I can't say that there's not a 2 fractured skull, because there's a medical report that says that. I can just say that my client may not have been the one who did that, Judge. I know that the complaint is a factual document because it's what the prosecutor uses. Everything else is hearsay, Judge. Now, in saying that, Your Honor, my client's 21. He is on probation, as brother counsel says, for these misdemeanor counts, Judge. And I'm not trying to say that the allegations are serious. They're very serious. But again, Judge, they're allegations, and they have to still be proven in a court of law. And right now, he's innocent of these charges until proven guilty, until he has his day, his pretrial day with Judge Bryant. He's gonna have a pretrial, Judge. Not gonna have an exam, we're gonna have a pre-trial, which is a misdemeanor. And they're gonna have to determine what happens at that point, Judge. And he's looking at up to 1 year at the Wayne County Jail as a maximum sentence, Judge, for one. So that's the reason why, Judge, I think that I'm making this argument. And, you know, Judge, and with all due respect to the court, and I have the utmost respect for the court, Judge, I just would ask the court to consider looking at what's in front of the court in terms of the complaint in the four corners of that, Judge. And I know you have to look at other things, Judge, in terms of what the allegation, I know that. But I'm asking the court to consider that's what he's charged with and set bond for. Thank you.
Thank you. Court does note that almost inexplicably, this was charged as a misdemeanor. Mr. Vincent, you've indicated that you've, quote, been in touch with the prosecutor's office. I presume that you were inquiring as to whether or not the charges would be increased. Would that be correct?
That's correct, Judge.
And did you get any response or?
We ended up, and it just happened a couple hours ago, Judge. We ended up putting you know, when I say the people, Judge, while I was working with this co-counsel, Ms. Douglas ended up putting in communication with the supervisor over there in an attempt to figure out what's going on. So with that being said, I do, Your Honor, I understand, at least right now, we have one aggravated, one misdemeanor. However, we still do also have an individual who was on probation at the time of this allegation. We would stick to our request. I appreciate everything that defense counsel has said. I do have a feeling that this is going to get taken care of, especially because I'm not going to let it go. So we're going to get a response here, hopefully pretty soon.
Okay. Is your client working?
No, he is not. He is not working for us.
All right, sir, while this case is pending, you are not to possess a firearm or any other dangerous weapon. You are to have no contact with Ms. Hamilton or her small child. Should you post bond, you'll be on a GPS tether on house arrest. You understand all of that, sir?
Yes, sir. So I got a cash flow.
One moment, sir. Court's going to set bond in this matter at $10,000 cash or surety. That unaffordable? That'll give us a bond redetermination hearing Monday morning, August 14. And the next date after that is a pretrial, September 27th, in front of Judge Bryant here in 36th District Court. Thank you, sir. You can step aside.